Well, the federal government's refugee swap deal with Malaysia is under legal challenge tonight. Lawyers have launched a High Court action on behalf of a woman and her 4-year-old son on Christmas Island. Her husband has been granted refugee status and is in Australia. The mother and the son arrived after the government announced that no new arrivals will be processed in Australia but will be sent to a third country. Lawyers say that removing the woman and her child breaches Australian and international law. Peter Lloyd reports.
Shame on this Prime Minister.
On the day the Coalition and the Greens combined in Parliament to demand the deal to swap refugees with Malaysia be abandoned, the government found itself fighting on a new front, the High Court. Late today, papers were lodged in a case that could undermine the Gillard government's so-called Malaysia solution before it even begins. It centres on the plight of this woman and her 4-year-old son, ethnic Kurds fleeing persecution in Iran. They arrived by boat on Christmas Island on the 16th of May. The woman's husband arrived 18 months ago. He is currently held in the Maribyrnong Detention Centre in Melbourne. He's already been granted refugee status and is awaiting clearance on health and security grounds. Normally that would entitle him to be reunited with his wife and son, but not after this.
Today I'm very pleased to be jointly announcing with the Prime Minister of Malaysia an innovative agreement on asylum seekers and transfer. It is a commitment to enter into a groundbreaking new bilateral agreement on irregular migration.
All 274 people who arrived on boats since the announcement are earmarked for expulsion. No exceptions, says the Minister, including for children.
We do not want to see children on boats, and as sure as night follows day, people smugglers would, if there was any blanket exemption, exploit that and say to people, look, if you put your children on a boat, they get to Australia and then they can sponsor you in.
Despite that apparently uncompromising stance, the Minister has at times hinted at exemptions. But it is clear that does not apply to the Kurdish woman and her son, now represented by lawyer David Manne. On the 7th of June, Manne wrote to the government insisting that both are owed refugee protection in accordance with Australia's obligations under the Refugees Convention. Manne argues for family reunion under both international law and the Migration Act. 2 days later, Gary Fleming, one of the most senior officials at the Immigration Department, sent this reply.
As you would be aware, on the 7th of May this year, the government announced that irregular maritime arrivals taken to Christmas Island after that date would not have their asylum claims processed in Australia. Minister Bowen has instructed the department not to commence processing of protection claims.
For the woman and her son who came to Australia hoping for a family reunion, the letter ended with this bombshell.
They continue to be detained for the purpose of removal to another country.
Last year, David Manne won the landmark High Court ruling that asylum seekers who arrive by boat and are held offshore can have their cases heard in Australia. The basis of this new action is that the refusal to reunite the Kurdish family is a breach of Australian law, plus a breach of 3 United Nations human rights conventions. David Manne is hoping for a hearing as soon as next week. Peter Lloyd, Lateline.
Well, Lateline approached the Minister for Immigration for comment. A spokesman for Mr Bowen said it would be inappropriate for the Minister to comment while the matter is before the court.